এই পর্যায়ে রয়েছে একটি আর্টিকেল, ডিগনিটি অফ জাজেস অ্যান্ড লয়ার্স, written by Advocate Azizur Rahman Dulu. He is a former judicial magistrate, a member and arbitrator, a mediator and arbitrator, BIMS IIM India. আমি আমন্ত্রণ জানাচ্ছি জনাব আজিজুর রহমান দুলুকে তার প্রবন্ধ উপস্থাপন করার জন্য।
বিসমিল্লাহির রহমানির রহিম। উজ্জ্বল আলোয় বিমসের আয়োজনত্রিক অনুষ্ঠানে মাননীয় প্রধান অতিথি বিচারপতি জনাব আব্দুর রশিদ, মাননীয় বিচারপতি জনাব আশরাফুল কামাল, মাননীয় বিচারপতি জনাব আহমেদ সোহেল, বাংলাদেশ সুপ্রিম কোর্ট বার অ্যাসোসিয়েশনের সম্মানিত প্রেসিডেন্ট ডক্টর নম্রতা পান্ডে, the chairman of BIMS, and distinguished present ladies and gentlemen. The title of the written keynote speech writing is The Dignity of Judges and Lawyers. Why the expression the dignity of judges and lawyers are to be required to discuss among us for establishing the dignity of the judges and lawyers? We have heard and we know that the dignity of the judges of the apex courts as well as the subordinate courts of Bangladesh is established through the Mazhar Hossain case judgment. I agree with the view to the judgment mentioned, particularly reported in 52 DLR, Appellate Division, page 82. In the Mazhar Hossain judgment, if we look into paragraph 44, that is the basis of the dignity of judges and lawyers. How? The answer has been given by our Honorable Appellate Division. In the said paragraph, it has been mentioned that a judge, whatever may be his level, is equivalent either with MP or ministers, as a judge is under the Constitution empowered to exercise the sovereign power. We often see the exercise of sovereign power by the apex court judges. That is our premises. But we do not often see the exercise of the sovereign power by the subordinate judges. It is true that without the exercising existence of the sovereign power by the justices of the Supreme Court of Bangladesh of both division, the sovereignty or the sovereign power exercising expression is not shown to the people as well as to the international arena. Under the line of that judgment, we can say that the tenure of the judges, the security of the judges, the dignity of the judges for both courts of Bangladesh, that is the Supreme Court of Bangladesh as well as the subordinate courts of Bangladesh, have been categorically mentioned and established, except having some lacuna which are to be still required to be fulfilled. For example, all the justices of the Supreme Court of Bangladesh are entitled and the dignity has been given to them as the dignity of the ministers. But in the warrant of precedence, if we look into the warrant of precedence which is existing in our country, in number 7, High Commissioners or Ambassadors have been placed in number 7. This is a questionable to the dignity of the judges of the Apex Court. Why? The judges of the Apex Court exercises the sovereign power like the ministers or the MPs. To some extent, the both functions of the ministers and MPs are challenged before the Honorable High Court Division under Article 102. And under Article 102, the judges of the High Court Division can review, and under that power, to some extent, the Supreme Court or the judges of the Supreme Court has the supremacy over the functions either done by the executive or by the parliament. Here we need to think how we can reach in that point. Another issue, the dignity of lawyers. It is universally true that if someone gives a new judgment or new dimension of judgment that reacts the minds of the general thinkers, if we get a tremendously exceptional judgment even in the Supreme Court of Bangladesh, a criticize may be happened in the entire arena of the Supreme Court of Bangladesh. Why? Because our minds are accustomed of having the generally established answer or the judgment. When we get an exceptional judgment, our minds are not able to have generally. And for this notion, when in the case of Ataur Rahman versus Bangladesh, one district judge brought this writ petition in respect of challenging the position of them in the warrant of precedence. This matter was raised and our Honorable Appellate Division has given the right judgment. But unfortunately, no lawyer has raised an issue regarding the dignity of the lawyer. It may be hard to you that this is an exceptional thinking. After hearing this thinking, a lot of criticism may be happened. So we should not raise this kind of notion. But after the emergence of United Nations, particularly in 2012, on 13 August, there is a resolution taken in the United Nations. In that resolution, which is available in my book, 9th book, in that resolution, the title of the resolution was The Independence of Judges and Lawyers. And in that resolution, at para 48, it has been categorically mentioned by all the participating countries of the world that like the judges of any countries, the lawyers should have the dignity, the lawyers should have the security, and the lawyers should have the independence. Otherwise, if only one side of a single coin is secured, dignified, and other side is not secured or not dignified, the coin may not be considered as a movable coin. The coin may not be considered as a genuine coin. It may be considered as destroyed coin in part. What laws are available in our country apart from the United Nations instrument taken on 13 August 2012? In our country, you can see 66 DLR Appellate Division page 1, 30 BLD Appellate Division page 1 and under section 21 of the Penal Code, lawyers are public servants. Our Appellate Division has declared specifically that lawyers are public servants, and as public servants, lawyers have a great role in rebuilding the society, in removing the corruption in the society which has been mentioned in the preamble of our country's constitution. In taking this notion of public servants, there is a law in our country, that is the Tolls Act. Under section 4, if a public servant moves one place of country to another place for his public servant related function, he will be exempted from toll. That is, a lawyer is also exempted from tolls under the Tolls Act. This is one of the examples we can say that the dignity has given by the British lawmakers in respect of ensuring the dignity and position of the lawyers. And lastly, I would like to conclude my saying in uttering the Jharkhand High Court judgment operative part. What point of law in respect of ensuring the dignity, security and independence of the lawyers has been categorically mentioned by the Jharkhand High Court in a case, that is, hence the state government of Jharkhand is directed to ensure safety, security and dignity of lawyers of the state by issuing a suitable circular in this behalf, directing police officials all over the state so that they may not indulge in the sort of activity of as happened in this case, and those who will do so will be considered to have violated the order of this court and will be liable for contempt of court and will be suitably punished. If this kind of order may come from our neighboring countries' apex court, we may also think the similar thinking for establishing the lawyers' dignity, security and other things, so that we may assist our apex courts as well as the subordinate courts of Bangladesh to ensure the justice all over the Bangladesh in getting a society free from exploitation as has been laid down in our preamble of our constitution. Again, I express my gratitude to all of the present honorable chief guests and other guests, and especially I thank BEAMS to organize this such of occasion, for which I have shared some information to think and rethink for establishing the independence of judiciary in our country. Thanks to all.